Jason about, oh, there's some cool cases out there. Not exactly IP, but they're really cool. So I thought I'd talk about them. And that's what the genesis of this talk. But to start, I'm just going to do a brief, one slide each, I promise, on intellectual property. If anyone has any questions, let me know. So copyright, very common. If you're a coder, your code is protected by copyright. It protects your creative expressions fixed in a tangible medium, which is basically anytime once you're finished with the work and you have it, whether it's digital or paper-based, you get copyright protection. You should federally register it. I'm sorry?
The question is, when I'm writing code, is it copyright from the moment I write it, or it's something I'm going to go to a attorney and get copyrighted after?
It is. The second you're done, it's in any form, it is protected. Now, federal registration is like the perfection of that right, and it gives you extra benefits, presumption of validity, statutory damages, which are awesome in copyright, by the way. Everyone remembers MPA and RIA in the early aughts when they would sue your grandmother for $2 million, $3 million because her grandchild had downloaded on Napster 20 songs. Statutory damages are awesome. They basically scale up to $250,000 per copyright infringement. It's really, if you're the copyright holder, content provider, copyright is awesome. Examples, literary works, music, film, architecture, which is odd, but yes, blueprints are copyrightable, and the actual home built from the copyrighted blueprint, if it is not a licensed blueprint, is actually an infringement. It's really odd. Trademark, those are basically source identifiers. It's a logo, like the Unikey logo, the Uber logo. You saw Uber, you guys knew exactly what it relates to, Uber company. And that's basically what trademarks are. They're source identifiers for a product or service, and you don't just get them, you do register them, but you have to actually put them into commerce, and you have to develop a distinctiveness or inherent distinctiveness, to get that right. All right, brings us to trade secrets. Trade secrets are pretty cool. That's just basically the inside knowledge that you keep confidential within your company. As long as it's confidential, not publicly disclosed, and only your employees have it, you can keep it as a trade secret. We keep it as a trade secret. Well, what ends up happening is someone takes it without your permission. For example, a rogue employee rolls off with your client list. That's a misappropriation of trade secret, which is a state law cause of action. And also recently, it can be a federal cause of action. There is I do not know the name off the top of my head of the act, but they federalized it just recently.
GDPR?
I'm sorry?
GDPR? Is that what you're talking about?
It might be. There's what, don't hold me to it, but there's been a federalization of trade secret misappropriation. So, what's interesting is, does anyone know what negative technical know-how is? I just learned that. I just thought it was pretty cool. It came up in the Google case I'm going to be talking about. It's basically stuff that doesn't work, but other people don't yet know this. And then when one of your employees rolls out with it and basically tells your competitor, don't waste $1 billion trying to do it this way, it's not going to work. Google already did it, and don't spend $1 billion on this, just don't do it. And that happens. It's kind of interesting. Patents is my specialty, and it's basically a patent grant it's a grant from the federal government to prohibit others from making, selling, or using your invention. They're not, basically anything that's a new device, method, technology. That's basically the patent.
What's the difference between a patent and a copyright?
A copyright protects artistic expression. It's not functional. It's basically something that's fixed. Usually it's a creative expression, music, artwork, sculpture. Patent is technology based. It has to be a device. It's got to be functional. Like you may saw on the last slide, trademarks can't be functional. It can't protect something that's functional. That's because it's the realm of patents. And sometimes patents and copyrights can bump up to each other. For example, software, you can get a patent on it and a copyright on it. But what's protected in copyright is the actual code, the literal code, or the look of your interface, not the actual functionality. So if you want the functionality of your software to be protected, it's got to be via a patent. So patents basically are functional ways, they protect the functionality of your devices and software. So it gets me into the cool stuff. All right. So these are the cases. So and you've probably heard about these cases. So Waymo Uber is so bloody cool because it just has bad idea written all over it. So everyone knows Google's been in the autonomous driving world. Probably they were one of the earliest entries. I mean, at least well-known entries. I mean, they've had an autonomous driving project for probably 10 years now. So they folded that into Waymo. You know, they became the Alphabet Corporation, and so they wanted to break off everything and make it its own little unit. So Waymo became the self-driving unit. So they have these little cars driving around. It's pretty cool, actually. So, of course, Uber is the ubiquitous ride-sharing service. Everyone uses Uber, right? You know. And so what ended up happening is Anthony Lewandowski worked at Waymo. He was one of their all-star engineers. He was just the man, right? And so he decided to go off and do his own startup. And I'm leaving, I'm going to do my own autonomous driving startup. Shortly thereafter, Uber buys it for well over $500 million. So he did great. But part of the reason why they bought it for $500 million is that right before he left, he downloaded 14,000 files from the Waymo database. I mean, he basically absconded with all the technical know-how and negative know-how, which was really important because Google spent billions on the earlier versions. And now, if you look at their newest version, their LiDAR system and all that jazz is much different than the original system. And that's because they spent many hundreds of millions of dollars figuring out what wasn't going to work well. And so basically this led to Google or Waymo lodging a misappropriation of trade secrets case against Uber. And you know, reason why. I mean, why is Uber being so aggressive? Everyone knows Uber is also involved in autonomous driving or developing these cars. And their former CEO, founder, whose name I cannot recall off the top of my head, but everyone knows him because he got pushed out of the board, or got pushed out of the CEO position last year for the culture issue that they were having at Uber. He basically looked at it as a winner-take-all scenario. Whoever gets that autonomous car out first is going to destroy the competition in ride-sharing. You won't be able to compete, and you're going to die with it real quick. So we have to get this. I don't care what we need to do. So there was this accusation that he basically had worked it out with Lewandowski to basically abscond, and it was all just kind of a sham to basically allow him to buy all that technology that Google Waymo had developed. So Waymo's not happy. They're really not happy. They demand $2.7 billion in damages. They didn't get that. And the trial was supposed to be 2 weeks. It settled, 3 days in? And they settled for basically $250 million. You know, so they got a chunk of Uber, and they already own some of Uber, and they also own some of Lyft. So Google's hedging Google's investment arm already owned a portion. I know they have I forgot what it's called, but they have an investment arm that owns part of Uber, owns part of Lyft also. And so Uber gives them the stock, and they promise not to use their technology in the future and to remove it from current devices. You know, it was interesting, you know. Oh, did it work? Here we go. More interesting, this Lewandowski guy is cool. So apparently he negotiated this whole deal, right? He kind of knew something was a little shady about it. And so Uber started investigating it themselves. He stopped cooperating, and so they fired him. Actually fired him. And he was set to testify at trial, but he had already made it clear that he was going to take the fifth if he was called to the stand. And you're like, what? Civil case, misappropriation of trade secrets? You can't do the fifth, right? Apparently you can, because the judge was so unhappy with the actions of Uber that he basically flagged it for DOJ to investigate it. Now they're kind of sitting on it right now, but because he did that, I believe, again, I'm not an expert when it comes to criminal law, but I believe that's what allowed him to invoke his fifth. So everyone wanted it to go away. Uber wanted it to go away. The new CEO of Uber wants to just get moving, grow the company, and be done with all the old stuff, and that's part of the reason I believe they settled. Plus, it was going to be really embarrassing. They're going to call the former CEO of Uber up, and he was already saying interesting stuff before trial. So again, that winner take all, we had to win. I mean, you didn't want him on the stand saying this type of stuff. So that's the Waymo Uber chase. It's resolved. And this is a common refrain. It was resolved. ADT Ring is the reason why I actually wanted to do this talk. Everyone knows ADT. They have those ubiquitous systems, home alarm systems. They have all sorts of security efforts. I think they do the armored trucks also. Ring, everyone knows Ring. I mean, they're the Shark Tank winner. I mean, they're the startup fairy tale company because they were a Shark Tank winner. They had, I think they called it the Doorbot. Really terrible name. They changed it to Ring, which was great. And you know, in the last couple of years, they've been improving their product, and it's gotten better. They got an HD version, a Pro version. They've smartly started to diversify their portfolio. Now they're launching floodlights, solar panels to power the floodlights in particular, and a security system. And I was kind of excited about the security system. I was like, oh, this is gonna be cool when it comes out. Well, it didn't come out. Not yet. So ADT wasn't happy. They sued them for misappropriation of trade secrets, and they actually won a trial. And after the trial concluded, the judge issued an injunction, which is just a court order saying stop whatever you're doing, and it was stop selling this product. So it was supposed to launch late last fall, didn't launch, and it was because of this. Why was ADT angry? Well, this Zonoff company was supposed to develop this tech for ADT called the Smart Home as a Service. I mean, everything's SaaS nowadays, including your smart home, right? And so they had loaned them. I can't remember what the number was. It wasn't much. It was like not much. It was like 60 million or something like that. Not much. Only 60 million. But they had secured it with the IP of the company. And so Zonoff was supposed to deliver this for ADT. They couldn't. They failed. And so what ended up happening, allegedly, was that the Zonoff people, or the founders of Zonoff, basically worked out this deal with Ring, like allegedly in the parking lot of the Zonoff offices, where they basically handed over like all their technical know-how for guarantees that they were going to hire them for senior engineers at their new alarm system division. Allegedly. Well, apparently it must have been allegedly because they won and they got an injunction preventing them from selling their new alarm system. So, of course, another common refrain, they settle. I think ADT got 25 million. Well, they got 25 million, but they're still not selling your system. It's not available. If this was much, it would say learn more is what these little buttons say. I tried to show you guys, they're still not available. They look like a pretty cool system. So hopefully we'll actually get to see that soon. Oh yeah, these are the cool ones. I love the murder ones. This is not my realm, but they're so much more interesting. The Alexa murder case. This was all over CNN last fall. Did anyone hear about this? This is pretty slick. So, background. Arkansas man is accused of killing his friend, a former police officer, after a night of drinking and football. You just know that's going to end poorly, right? So, I know, right? So the victim's blood alcohol level was 0.32, which is really bloody high. I mean, it's 4 times the limit in Arkansas and Florida. I mean, you can't be conscious at 0.32. It's one of those things. He was found dead, floating in the defendant's hot tub. Defendant was inside the house sleeping. He said, I don't know what happened. Clearly it was an accident, So the prosecutor in the case wanted the recordings from Amazon because there was an Echo device. This guy was Mr. Smart Home, by the way. And so they subpoenaed Amazon for those recordings, and they told him to pound sand. But of course, I think afterwards they're like, you know what, we got nothing to hide, so we'll consent. Once they consented, Amazon provided them, and because they had argued it was a tragic accident. And here's another thing. So the police still didn't believe it because they're like, you have a smart water heater, and the smart water heater says you were like filling something up with water around 2 in the morning that morning. That's kind of shady. It looks like you may have killed him, filled up the hot tub, threw him into the hot tub, and so that's their position. I believe the case is still pending, but I don't know if it's going to go anywhere because he had a good explanation apparently for that water usage. But it's interesting. They should know with all these smart devices that if there's a criminal case going on, they're going to try to get their hands on that data. And it's depending on if it's the victim's data, then they're going to get it. There's no one to really worry about privacy there. But if it's yours, it's an interesting part of the law. The most common thing that we're seeing is the phone.